additional option. Also, I'd like to mention item number 15 option.
1.5.
We have received the additional affidavit only this morning.
Okay.
Would like to examine the additional affidavit.
Additional affidavit in which IA or
In the eye.
in the IA?
They're explaining the thing.
Okay. Yes, Mr. Burwa.
Can we fix the matter on 14th of January?
14th. This is 2020.
Oh, that is 25.
Okay. Mr. NK, CD Ramsam, Learned Council appearing for the opposite parties in I Civil 83/2025 has submitted that he has received a copy of the additional affidavit in opposition, additional affidavit filed by the applicant, explaining the delay from only today. Okay, only today, and so he has just submitted that the matter be posted on a matter be posted on another date in order to enable him to go through the same. Mr. N. Burwa, Learned Counsel for the applicant. This applicants, appellants, who is present, has agreed to the said submission. Gustav has sought for and agreed to by the Learned Counsel for the parties, list the case on 14th January 2026. Yes.
There was a major fish today. However, it's not listed today. So I believe that it will be taken up as a last item for tomorrow.
What is the matter
It
about?
was a criminal appeal filed with one IA. IA was for suspension of sentence, and the suspension of the sentence was to be considered today. However, it's not listed. So I believe that it will be taken up as last item for tomorrow.
Okay, tomorrow. Tomorrow.
Yes, ma'am. That is my workers.
Yes.
Since I back to mention 18, 19, 20.
Yes.
In 99, the petitioner, led by my senior Tali Ao, is not doing well, so the matter of the petition.
Okay. Who is for the appellant in the state appeal? Yes. Huh?
I am not 19.
You are in 19.
Yes.
Okay. Miss V. Sukri, Learned Traditional Advocate in Nagaland, for the appellants in 18 and 20. Right, the appeal number. And Mr. Jed Anguli,
Yes.
Learned Central Government Council for the Union of India.
I am appearing for the NHIDCL in item number 20.
And are present. Mr. P.J. Soike, Learned Senior Counsel. In your item is?
Item number 20.
Okay. You are for?
For NHIDCL.
Okay. For the respondent, NHIDCL is present through video conferencing mode. Mr. Foseko Forte, Learned Counsel for the appellant in REIT appeal number 2/2024, has submitted that Mr. Taliao, Learned Counsel, who is
not objected to by
disposed.
counsel for the
Citing the ground, Mr. Forte has prayed for listing of all the appeals immediately after the ensuing winter vacation. When do you want? February?
My lord, 4th of February, my lord.
4th of February,
Lordship, I think in the January, Your Lordship.
January, 21st January,
Lordship.
Lodge.
21st? Okay. As sought for by the learned counsel for the parties, list the cases on 21st January 2026.
Applies.
Back to mention item number 17.
Yes.
Down for the appellants. Actually, we have some difficulties today.
Why? Criminal appeal. The right to life, personal liberty is involved. You are not prepared or what?
Lordship.
Hmm? Or you are led by some else?
Yes, line, I see him, After the vacation, no.
On the prayer of Mr. Posego Hotel Learned Counsel for the appellate. List the appeal on a date immediately after the ensuing winter vacation. As the learned additional power, as who is the public prosecutor? Also, it is submitted that consent has been taken from the learned public prosecutor Nagal to make the prayer. Okay.
This Lordship, Lordship, I like to mention item number 21.
Yes, ma'am.
It's on joint prayer, Your Lordship of the parties, joint prayer. I pray that this matter will be listed after the winter vacation.
Okay, choose a date. Then agreed date. Any agreed date?
Yes.
21st, okay. Mr. A. Jimomi, learned counsel for the appellants. Ms. V. Supi, learned additional advocate general Nagaland. And Mr. Takamasa, learned senior counsel for the respondent number. It is there in the cause list. I made a joint prayer to list this appeal for hearing on 21st January 2025. As sought for, list the appeal on 21st January 2026.
For admission, item number 1.
Yes,
This matter is like the
indigenous inheritance certificate.
IMT in Assam,
I am.
illegal migrant
Okay,
examination.
okay.
Lordship was
Ah,
sitting in the division in a special bench on the appeals, on the orders passed by the tribunals. I've seen many cases, most of the cases were dismissed in case of Assam also. Here, Lordship, the petition is filed by the Nagaland Tribes Council. Earlier, till 1977, 3 conditions were laid down by the state. And 1/12/1963, that is the day when the
Statehood.
Nagaland got statehood. Besides that, there were 3 criteria which is required to be fulfilled for determination. That has been followed for the last 61 years. Now, since this issue has arisen, some representations have been received by the state. So a commission was constituted. Commission has thoroughly examined as per the terms of reference given to the commission, and we have submitted a report. In a very clandestine manner, the governor has mentioned about the recommendation of the commission, saying that in terms of the recommendation of the commission, however, although it is mentioned, they have not acted strictly in terms of the recommendation of the commission. Now, the latest order of 20th September 2024 is, yes. If we go by that, the village council has been given the sole authority to determine and issue a recommendation, a certificate. Now, let us anticipate the situation, and that is happening now. If a group of persons occupy a place, if they have money, they will purchase a big chunk of land, and then they will form a village. That is the practice in the state of Nagaland, that a group of persons will carry together and then they will form a village. In due course, they will seek for recognition of the village and the state government will recognize. So it becomes a valid village authority in accordance with law. Now, if recommendation is issued by the village, non-indigenous people, they assemble together and form a village and government recognize such a village. Then they will become indigenous inhabitants. That is how we are agreed. A rich man may purchase a big chunk of land and he will put so many people. Invariably, it will form a village. And then state government will recognize that village.
So you are agreed by the changes in norms.
Yes.
And dilution in norms.
Exactly, Lord.
From the notification of 77.
And the
recommendation of that council.
Exactly, Lord.
But so far as interim period is concerned, it is up to 1 year back. Deletion of this.
It may be considered on the next
Okay.
stage. Lord.
Okay, we'll issue notice also on the interim period.
What are state respondents? Lord?
Yes. Heard Mr. C.T. Jami, Learned Senior Counsel, assisted by Mr.
Aliba Ozekam.
Learned Counsel for the petitioner, and Mr. Imti Ingchong, Learned Petitioner agent. For all the respondents.
All the response.
All the respondents supposed to. The petition has stated that, which is the notification earlier, 77.
Earlier notification is lordship at page 57.
The matter of granting indigenous inhabitant status was continued to be governed by '51.
57 lordship.
57.
Filter is not written correctly. Annexure to
By a notification dated 28/4/1977, issued by the Personal and Administrative Reforms Department, Government of Nagaland, wherein 3 specific criteria were laid down for grant of indigenous inhabitant status. Full stop. Subsequently, a commission was constituted by the government by the notification dated 27/7/2019 to look into the matter of grant of indigenous inhabitant status, and the commission made a series of recommendations for regulating to regulate the grant of indigenous inhabitant status to a person, and a report was submitted by the Commission on a Register of Indigenous Inhabitants of Nagaland, RIIN. Full stop. Though based on the recommendation, the state government, partly based on recommendation, on the recommendation of the Commission on RIIN, the state government has passed an order. The Home Department, Government of Nagaland, passed an order on 20/09/2024, whereby the norms to grant indigenous inhabitant certificates have been laid down. Full stop. It is the contention of the petitioner that while laying down the norms, comma, the order overlooked. While laying down the norms, comma, the recommendation made by the Commission on RIIN have not been adhered to, thereby making the norms
Diluted or
diluted, and as a result, comma, non-indigenous, there is every likelihood that non-indigenous persons would be granted indigenous inhabitant status. Issue notice returnable in 4 weeks as Mr. Imsom, learned edition advocate of Nagaland, has appeared and accepted notice on behalf of all the respondents. Issuance of formal notice to the respondents is dispensed with. Extra copies, however, the Land Council for the petitioner shall furnish extra requisite number of extra copies of the memo of appeal with annexer to Mr. Imsom within 2 working days from today. The state respondents shall ensure that its counter affidavit is filed on or before the returnable date. Issue notice also on the entire prayer. The notice is made returnable in 4 weeks.
For admission, item number 2.
Highway. Yes, for what?
The order dated 1911.
1911. That's one of the stating whether they have been following the specification introduced by Sweden while constructing the Kohima Mao Road. Council for the responding shall submit against the affidavit the status report of case that by the number 700 complete section of the road by the contractor. The general manager PMU submits over sinking area and a landslide that has occurred near Kohima has now been taken care of in a temporary capacity, and the same should hold up for some time. At least you could certain that how long it will last. Otherwise, the work done and given to KAJ for submitting a DFR for creditors. The land says the timeline. Okay, first, the short issue. That landslide occurred near Kisama.
Yes, ma'am.
It was holding. It is holding.
It is holding.
It is holding.
They have restored it now.
Okay,
But that's just temporary.
temporary.
Yes.
Now, the peers.
That stage is there.
So that issue did not be taken note of. This
Yes, ma'am.
temporary capacity is submitted that landslide that has occurred near Kisama
Yes, ma'am.
has now been taken care of in a temporary capacity. And he was unsure that how long it would hold.
Yes, ma'am.
Then thereafter, one existing road and an alternative road is contemplated. Okay,
Affidavits have been filed this morning.
Oh.
Are they on the recording options?
that we don't know.
2 affidavits have been filed, one by the initial ECL and one by the authority engineer.
Any
And I
evidence?
received copies just this morning also.
This one is 28.
Any idea?
The authority engineer has not been found.
Mr. Moajami, you represent NHIDC.
Yes, sir.
And Mr. Sentianger,
Authority engineer.
authority engineer.
Yes, sir.
Authority engineer is under NHIDC.
Yes, sir.
Okay. So what is your affidavit?
paragraph 2 of the.
No. It is on DPR.
Yes.
DPR.
Yes.
Which one? Existing road or the alternative road?
All, both has been mentioned in the report. The first is, we are accepting the contractor is constructing the road as per a specification of mode. That is our first statement. Second motion, we have to put it as consultant, if you are consultant.
Okay, first one is that Kohima Mao Road, whether the construction is as per the specification of the Ministry of Road and Surface Test.
Yes, boss.
Okay.
Stated in paragraph.
Status report of the test done by the respondent number 7. In the previous order,
Lord.
the respondent number 10, who represents respondent number 10, shall also submit in his affidavit the status report of the test done by the respondent number 7. Who is respondent number 7?
Contractor.
Contractor. So, you have brought it.
Yes, my lord.
Huh?
I have brought it on the court, my lord.
Okay, affidavit
I have
today.
this morning.
Yeah, affidavit.
Yeah.
Responding to this one.
Which one?
Probably
Those
not
are
received.
11 now.
Probably not received.
Oh, those are not on file. Not on file.
Well, fine. No, your worship, it is one number 10, was found a chart of tests done. But the prescription of the standards, it is not, there is no comparison with the prescription of the standards.
Okay.
So if a comparative chart is given, that will be much better.
Then in
Let
that
us,
case,
let us
I will be-
have a look at your affidavit.
This is a chart that the level analyzed to raise.
Yes.
It's for you to use, my lord. And the next annexure, my lord, is a certificate.
Oh, what do you have said? What is the relevant paragraph? Shall file affidavit, last quality is conducted by present document and are placed on record. The team led by has been constantly deployed on site to monitor the progress of work, quality of works. The status of the work was of the core component by the engaged contractor as also and so. Work executed by DT as per executive plans created so and so it was organized. Bituminous roadside train. Or the
The same. This is the same one.
this is this one update.
Same.
The court observes whether you
Respondent number 10.
this contractor is following the specification.
Yes.
This my lord. Respondent, my lord, he, the contractor is 13, not 7.
7 is the state.
7 is same.
Okay, it should be 13.
13 is supposed to be.
So whether this is the work done.
Yes, my lord.
Now, further stress is on the quality of work done
Yes, my lord.
as per the parameters.
Yes, my lord. So.
There is nothing on it.
Now, otherwise, my lord, in annexure 3, my lord, at page 12. There is a certificate, quality certificate, certifying that the various items of work executed during the period stated above conforms to the specifications stipulated in the contract and the test check carried out by the authorities engineer.
But it is without any signature.
My lord.
Without any signature and no statement.
My lord, in that case, my lord.
No statement on oath.
My lord. In that case, my lord, I may be permitted to file an affidavit.
I think
For the next day.
it should be certified by this general manager
My
or
lord.
all
My lord.
with their signature and there should be a statement on oath,
My lord.
the affidavit.
Yes, madam.
Then only.
And there should be a comparative chart as well.
Ah,
Standard prescribed.
I'll incorporate the comparative charges.
Okay. 1 minute, that is one. Lest I forget.
Yes.
A. Jimomi learned amicus, huh? Imti Imchong, learned additional advocate general for the Nagaland for the respondent number 3, 4, 5, 6, 7, and 11. Go to the earlier order. Who represents? Okay. Okay. Senti Anger, 10. Moa Jamir, learned as Standing Council NHI DCL
Lord.
for 1, 2, and 8.
Lord.
And Mojui, 13 and 14. Okay, anybody from NH, National Highway present today? No.
Representing the board.
Huh?
Responded to one.
Okay. On the previous date, the respondent number 10 was directed to submit an affidavit with a status report of the test done by the respondent number 13, within bracket, incorrectly referred as respondent number
13. By respondent number 10, respective to who carried out by respondent number 13.
respondent number 13, within bracket, incorrectly referred as respondent number 7.
13 is the contractor member, 10 is the authority engineer. So the authority engineer carries out the test. Respondent number 10 carries out the test.
Okay, the answer for respondent number 10.
So these are.
No, who is the respondent number contractor?
Yes, 13 is the. 13.
Was directed, the respondent number 10 was directed to submit an affidavit with a status report of the test done by the authority engineer.
Yes.
Within bracket, respondent number? Okay. Sorry. The status report of the test done by him. Done by him.
Yes.
Done by him. On the completed sections of the road by the contractor, respondent number 13. In the Kohima Mao road stage. Post up. The test done. The test was to be done in comparison to the specification introduced by the Ministry of Road Transport and what is MORTH?
Transport and highways.
Highways, Government of India. Post up. An affidavit on behalf of the respondent number 10 has been filed in deference to the direction made in the order dated 19/11/2025. Post up. Having gone through the contents of the affidavit, it is noticed that the respondent number 10 had conducted a quality test and submitted a progress report. I has also annexed a progress report. Post up. Progress report or in respect of the respondent number 13. Post up. However, any comparative table regarding compliance with the specification of the MORTH Government of India. However, the affidavit is silent as regards any comparison of the work done for the specification laid down by the MORTH GUI. Also, where Mr. Sethi Iyengar, Learning Council, for the respondent of 10 has submitted that he will file an additional affidavit in continuation of the affidavit filed on 10/12/2025 by the next or before the next date of listing. So stop. That is one. Okay.
sir.
What is the next?
Next one is the certificate filed by the initial ECL.
NHIDCL. Where is that
This
NHIDCL?
one's to the.
2 and 8.
Next one. Wait. This one. And this is with regard to the DPR levels. So, you see the statements.
Not there.
It's not there. No. We filed earlier in the.
I can finish my.
Earlier in November.
The statements in paragraphs 4, 5, and 6.
The respond number 1, 2, and 8
Yes, also, Mr.
has also filed an affidavit in reference to the order dated 19/11/2015. Para.
Paragraph 4, 5, 6.
1 minute. These parameters are in annex are A perhaps, which Mr. Santi Iyengar has to confirm.
Yes, ma'am.
Huh?
But quite different, ma'am. The test carried out and what the Mr. Sanjay has filed are quite different.
This is the guideline.
This is part of the guidelines possibly.
Okay, this is part.
Yes, no, part of the guideline. Relevant of the guideline.
Okay, the start is not with us.
Yes.
The first page is not with us, so we cannot say what kind of guideline. Okay.
The test report gives us values, ma'am.
Right.
Yeah, so there's no values, so we won't know.
So whether it is the work done by the contractor conform to the standard laid down here, you have to get the affidavit. Is there any date of the parameters? Date of the guidelines? Any idea? Have you mentioned?
Oh, we have to mention the need of the guideline, mention it paragraph 2 of the.
You have annexed the guideline requirement without the head and tail,
What?
right? So it is difficult for us to refer. Which paragraph?
Paragraphs 4, 5, and 6. This is with regard to the DPR. For the permanent solution in respect of the collapse portion. As well as generally strengthening of the entire stretch.
The respond number 1, 2, and 8 was directed to submit a DPR for strengthening the existing road where the landslide and the sinking area has occurred. So completion date is 5/5/2026.
For a DPR. Just for a DPR.
Just for the DPR. Okay. And the affidavit so filed, comma. NHRC has depicted the line of action, including the working methodology and schedule of works submitted by the DPR consultant. Messrs K and G Projects Private Limited. Full stop. As per the timeline indicated in Annexure C, the work has commenced on 5/11/2025. Full stop. The timeline for different items have been mentioned therein. And as per the program of the DPR for Kohima Mao Road, the detailed project report is to be submitted on 5/5/2026. Any alternative one? Now this is the existing one.
Yes.
What is the DPR about?
The
Alternate.
paragraph number 5.
You use some abbreviation, we don't understand. COS.
Change of scope.
Huh?
Change of scope.
Change your scope.
Change of scope. We know scope of work. Change of scope.
Yes, boss. Because it's deviating from the main plan.
Okay. Yes, what do you want to say? Anything?
The worship, on the last occasion also, just for the DPR, till the month of May, it means we lose one whole working season. Just for the DPR.
This is the working season.
Yes. Unless they can explain.
Correct approval, draft,
In that
proposed,
process.
also presented for 11 was valid, wait for some. And length of corridor may be optimal process now. Before that, on the next date of listing, the respondent number 1, 2, and 8 shall submit an affidavit with regard to the progress achieved vis-a-vis the timeline prescribed for the DPR in Annexure C to the applicant. So for first one. Now, so for second one, what to do? Alternative route.
This,
They are saying some technical
I'm
terms.
saying this is something they came out by themselves.
Good
We
enough.
offer it, good for them.
Good. Otherwise, the proposal is good.
Yes.
Okay.
Otherwise, our main concern was only the main road.
Main road. But this is additional benefit.
Fully put-
As regards the alternative route, for Kohima to Mao, contemplated by the NHIDCL, as indicated, as submitted earlier, it is averred that the study for alternative corridor of Kohima Mao and DPR preparation is presently in progress and the work is being executed by Messrs. Stanley Consultants Inc., USA within bracket JV with Messrs. Caritas Infra Consulting Private Limited. Full stop. Drone videography was conducted on 26/8/2025 and 27/8 in August 2025. Full stop. In a meeting held on 11/11/2025, the DPR consultant was directed to make final presentation on proposed alignment options and their comparisons. Full stop. Approval was accorded by the NHIDCL on 13/11/2025 on change of scope COS for DPR preparation and study of alternate Kohima road corridor, Kohima Mao road corridor. Full stop. The draft proposed alignment options was also presented before the highest authority in the NHIDCL. MD is the highest authority?
Yes, sir.
On 4/11/2025. And on such presentation, the authority directed to explore some more options and length of corridor. And for optimization of the length of corridor as per site conditions. And these are some technical things. It requires time
Yes, sir.
because of the terrain. Okay. So a progress report
Lord,
on the alternate road,
Lord.
same next date. Okay. The respond number 1, 2, and 8 shall also apprise in its next affidavit the progress made on the DPR preparation on the DPR for the alternate Kohima Mao road. Right? So both
Lord,
should be addressed.
Lord.
Yes, anything left?
That's all.
So shall we fix a date?
Um,
Okay.
21st January.
I think people will be working here.
Should be, Lord.
Huh?
Yes, sir.
During Christmas vacation? Or one more week? Let us be in
28 January.
28 January 2025. 26. Please the case.
But then, if we come. For admission, item number 3.
Here you are the petitioner.
Yes, sir. You're in the mission.
And Mr. Portavoy.
Yes, what is this road?
This is National Highway 329A. Your Lordship, this is the alternative route whenever National Highway 29 is blocked.
329A. Uh-huh.
The road
What is the road from direct road from Kohima to Dimapur? NH
NH 29.
29. Okay.
So this is the alternative route whenever National Highway 29 is blocked. The long circuitous route that comes out in Jhanapur.
Up the hill.
Yes,
Ah.
this is that road. So
Okay.
my letter and order dated 17/11/1.
Is it part of the record?
Yes, ma'am. In PI number 3 of 2021. This honorable court directed that this road should be constructed within a period of 3 years.
Is it part of the record?
Yes, sir.
The judgment?
Yes, ma'am.
Where is the PL?
Page 41.
Or the PL?
Yes, my lord. You know, page. Relevant portion is page 41, we take it from page 17. It's 17.
Okay. 70. So, this 329A, 329A,
Yes.
17/11/2011. Okay, any other, the government, wherever taking the engineering on the villages, now. Direct. So, Ministry of Road Transport and Highways and Government of Nagaland were directed to construct, expand, maintain
Yes, ma'am.
NH 329A as any other national highway, and it should be done at the earliest but not later than 3 years. That is the order.
Yes.
Ah.
That hasn't been. Yeah, so I came to for example again by way of this second PI.
So it was supposed to be completed by November 2024.
Yes,
It was not, progress was not. Had they started something?
nothing, my lord, nothing has started. The process of the DPR preparation has been started. So
When?
the last-
After the new
after
second
the-
PI?
Yes,
Okay.
so on the last occasion, the Central Government Council was instructed to, or directed to obtain instructions as to the status of the DPR.
Okay. Okay. The region we first mentioned, so that in the judgment rendered on 17/11/2021 in PI in IA, in IA or
PIL.
in PIL or IA?
It's clubbed together, my lord.
Okay, what is a PIL number?
PIL.
3/2021, read with, and I civil 72/2021, comma, the government of the Ministry of Road Transport and Highways, MORTH, Government of India, GOI, and the Government of Nagaland were directed to construct, comma, expand and maintain National Highway number 329A as any other national highway, and a specific direction was made to complete the same at the earliest, but within a period of 3 years. Full stop. Para, as no progress seemed to have been made as per the above direction, comma, the PL, the instant PL is preferred. Full stop. Para. Where is the previous order?
3985.
Yangarvati.
Yes, ma'am.
Your Lordship, on behalf of my senior Yamavati, Your Lordship, we are yet to receive instruction on this matter.
Your client is not cooperating or what? Do they have any office here?
What? No, no, no.
No.
No, Your Lordship.
What is their task on the DPR? What role they play?
Your Lordship, the highway itself has to be built by the bonds. So the DPR is a part of that process.
They delegate it to
Agency.
agencies, either NHAI or NHIDSL, who in turn delegate it to the contractor by tender. You represent whom? Do you have any role here?
No,
No, not yet.
no, they're actually.
Not yet. And Mr. Seki?
Lordship, I'm the intervener here, the respondent brigade, Mahinamsi village. My village is also in the same stretch, my lord. And we
So
cannot
you
follow the
sail
road.
along with the PL petition?
Yes, your lordship.
Okay. Where is Mr. Yangarvati?
Your Lordship is in this post.
Indisposed. So connection is snapped.
Yes, sir.
We put it then. No way, Mr. Yengavati, you are not the Central Government Council.
No.
What role the government of Nagaland has?
No road actually.
No role.
National highways is purely north. Going on.
Purportedly for Mr. A. Jimomi, heard Mr. A. Jimomi, learned council for the petitioner. Who is for the state? Earlier it was LT Sanctam, Mr. N. Mojui. Oh, sorry, N. Angami. N. Angami.
Yes, that is sometime the.
Learned government advocate on behalf of Mr. LT Sanctam, learned additional advocate general Nagaland for the response number 225. Mr. Moa Jamil, learned standing council NHIDCL for the response number 6 and 7. And Mr. Joshua Seki, learned council for the response number 8 intervener. Post of Mr.
Wasilezo.
Learned council appearing on behalf of Mr. Yangarbati, learned central government council for the respondent number of for the Union of India, including the Ministry of Road Transport and Highways, has submitted that no instruction as regards the DPR, no instruction as regards any decision on the DPR required for National Highway number 329A has been received by Mr. Yangarbati, CGC, till date. So, Mr. So-and-so has further submitted that as Mr. Yangarbati is indisposed, he is not in a position to highlight anything in the subject matter. In view of absence of Mr. Yangarbati, CGC, on the ground of his indisposition, let the case be again listed on this we can fix on 21st. 21st.
Are instructions to be submitted positively on the next week?
Post of the Ministry of Road Transport and Highways, Government of India, shall ensure that its decision on the DPR pertaining to NH 329A is placed before this court on the next date of listing.
For admission, item number 4.
May I plead, Lordship? Lordship, I am appealing on behalf of the petitioner.
Yes, earlier period was up to what?
Up to 2nd December, Lordship.
There has been extension.
Yes.
Yes, you bring it on record and madam, then you get the relevant records on the next date. We'll decide the street petition. Immediately after vacation on 14th, you get the records. You bring the extension on record by open affidavit.
Lordship.
So that we post it, we'll decide it.
Lordship.
Yes, Mr. Counsel.
Lordship, since it's a habeas corpus petition, no doubt I have been informed that my detention order has been extended. And this honorable
We have the extension order? No.
No, Lordship.
No. Okay.
But I have been informed that my extension.
You place it. Yes. Yes.
Lordship, I was just praying that no doubt, I don't know whether my learned counsel has placed that extension order before the honorable court or not. But since it's
not placed, but he has instruction.
okay.
Do you have the copy?
Yeah.
Oh, he has the copy. So do you have any associate here?
Lordship, if this
It
honor,
can be handed over to your associate.
yes, Lordship.
Okay. You get it on record. And madam, in the first order itself, records of the detention proceeding. Next date, positively. Because if the first order is bad or procedure is not followed, subsequent order is bad. You have the records.
The record is
Okay.
already there, but there was an extension, so we want to. So on the next, on the
No,
next.
extension is based on previous orders. We can hear it today. Yes.
Lordship, if this honorable court desires, I am ready for hearing today, Your Lordship.
Okay, let us see.
Is it?
Huh? Okay.
Your Lordship, I'll go into my records because I was of the impression that this record will be challenged. I mean, it will be broken record by the petitioner.
This is extension only.
Yes, it's an extension.
This is based on the original order.
Yes, sir.
If the original order is bad,
Yes, sir.
then all subsequent orders are bad,
Yes, sir.
right? Or crucial period is first date of detention up to the first 3 months.
All right.
Subsequent orders are only based on the previous thing. Whether PIT NDPS advisory board considered it or not, when representations were disposed of or not, the procedure compliance was there or not, right? Are you ready?
Lordship, the records are with me.
There are other matters also. Okay, then we'll post it. Okay.
Lordship, after the
Third,
extension.
Mr. P. Shurian,
Lordship.
counsel for the petitioner, through video conference mode, along with Mr. Medovero, learned counsel for the retinue, and Ms. Livika, learned government advocate. Nagaland, post of Ms. Livika has submitted that the detention period of the retinue has been further extended from 3/12/2025 to 2/3/2026 by an order dated 2/12/2025. Post of Ms. Livika has handed over a copy of the order dated 2/12/2025 to Mr. Medovero, who has submitted that he will bring the extension order on record by way of an additional affidavit. Post of list the case for in the admission column on 14/1/2026. Post of an endeavor will be made to dispose of the petition. Post of Ms. Livika, the government request shall ensure that the relevant records are available with her for perusal of the court. Available with her on the next date of listing. On 14/1/2026.
Lord.
Right.
For admission, item number 5.
Because Lordship, in this matter, detention has been revoked. So the
Okay.
case become just.
You are released. And Mr. Paki Richanbo, learned counsel for the petitioner retinue, and Ms. Livika, learned government advocate, Nagaland, for the respondent number 1, 2, 3. Anybody for, yes, Mr. So-and-so, learned counsel, on behalf of Mr. Yangarabati, learned central government counsel, for the respondent number 4, post of. This petition was referred to a sale, an order of preventive detention passed on Where is the order? passed on 5/6/2025 under section 3 within bracket 1 of the Prevention of Illicit Trafficking in Narcotic Drugs and Psychotropic Substances Act 1988 PIT NDPS Act, whereby the petition, the detainee was ordered for preventive detention for a period of 3 months. Post of subsequently, the period of detention was extended by a confirmation order dated 6/9/2025. Post of for another period of 3 months. WEF 7/9/2025 to 6/12/2025. Post of para. Ms. Lipika, learned government advocate, has placed a copy of an order dated 6/12/2025, passed by the respondent number 1, whereby the respondent number 1 of the state government, in exercise of the powers conferred by clause small a bracket of subsection 1 of section 12 of the PIT and DPS Act, has ordered for release of the detainee forthwith from detention, with an observation that he will be tried for a case registered against him as per law. Post of para in view of the order dated 6/12/2025, there is no releasing the detainee from detention forthwith, there is no surviving cause to proceed further with the writ petition. The writ petition is accordingly closed. Post of a copy of the order dated 6/12/2025, passed by the Home Department, Government of Assam, placed by Ms. Lipika, is kept with the case record by marking it as document X.
For admission, item number 6.
Yes.
The main challenge with this petition is that the grounds, except for the grounds of arrest, all other documents were handed in a language which is not familiar to the detainee.
Is it your case in the representation?
Yes, Your Lordship.
Let us go to the representation.
It's at page 75.
75.
And it shows 16, pair 3.
75.
It starts from page 75. The relevant portion is at page 76.
76.
If I may read, Your Lordship.
I have seen.
Yes.
Now let us see your record. That proposal.
Yes.
Or arrest memo. Arrest memo is available. You are a man from Rajasthan,
Yes, Your Lordship.
caught in Nagaland,
Yes, Your Lordship.
41 years.
Yes, Your Lordship.
Durg Singh,
Yes, Your Lordship.
5950 grams. Suspected to be brown sugar.
Yes, Your Lordship.
23 crores value.
Yes, Your Lordship. Your Lordship, however, in this case.
No, we are just looking into the facts.
All right.
You are in Kohima district jail.
Yes, for a time being, I was there.
What is your qualification, educational qualification?
Class 7 in medium.
Class 7.
Yes, Your Lordship.
Where have you stated?
I haven't
Then where in?
It's there in my arrest memo. Arrest memo.
You have not stated. You have not stated. Page 76.
Yes, yes, Your
No,
Lordship.
it is your own statement.
I have only stated that I can only read and understand Hindi.
That for region for only being able to read and write Hindi should be vis-a-vis the qualification.
Yes, Your Lordship.
In your representation, you are silent.
Yes, that was an oversight.
Oversight, this is a case of habeas corpus, preventive detention. Every ground is to be ours specifically.
Yes.
You have just said, read and understand. What does it they say in the affidavit in opposition?
In the affidavit in opposition, they say that grounds have been explained to me in the language that I understand. However, this is untenable according to the law laid down in Hare Krishna Singh's case, also lordship, and Murtuza who say it's a case.
Right. We have to get satisfied.
Yes, Your Lordship.
From your statement, you simply said you should controvert this that my education qualification is up to class 7.
Yes,
If you say so, then it is a good case for consideration. Yes, madam, do you have the records? Records you have? Yes. Let us see how you served the copy. And also let us see the PIT and DPS, advisory board.
We received, we have said, but the report is yet to be received.
Because he might have been examined.
Yes.
And though it is not open for him to see the advisory board report, it is open for us. So,
I've been informed that they have said recently, one.
okay, one more thing. You were in custody
Yes, Your Lordship.
for commercial quantity.
Yes, Your Lordship.
Did you prefer any application for bail?
Yes, Your Lordship. Before the special court, and also it was rejected there. So I preferred another one before a single bench of this High Court, which was also rejected, Your Lordship.
Rejected.
Yes, sir. So
So you bring those facts. You are.
it's enclosed, Your Lordship.
Let us see High Court order.
It's page 15. Page 70 and extra 5. Your Lordship.
Okay. Which page, madam? That the detainee was served with the grounds of detention. Any?
Yes, the state means.
Since when you are in custody?
Since 12/6/20, they are.
In NDPS case?
It was 7/10/25.
7/10/25. 7/10/2025.
Yes, Your Lordship.
And in preventive detention?
No, in preventive detection is from 7/10/25. My initial arrest was on 6/12/2025.
Huh?
6/12/2025.
No.
12/6/2025.
No.
12/6/2025. I'm sorry.
Grounds of detention was served in Hindi.
Yes, sir. But
Yes, Your Lordship. Except for that document, all other supporting documents were in English. In a language that I don't understand. No translations were given to me of the material documents.
Whether you have ever in the repetition that you read up to class 7?
No, Your Lordship.
What are the documents you were served with?
Uh, means, sorry, I've listed in there are 3 of my petition, Your Lordship. It's a list, exhaustive list, Your Lordship.
Exhaustive list.
Yeah, which comprises from annexure 3 to 14.
How they have controverted it?
That it has been explained to me in Hindi. That's I received the affidavit only this morning. Yeah, that's what paragraph. There's controverted that in paragraph 4.
What is read the statement?
Yes, Your Worship, if I may, it's their affidavit, paragraph 4, Your Worship. That with regard to the statements made in paragraph 3 of the writ petition, the answering deponent does not admit anything which is contrary to the records. The answering deponent further states that the detention order dated 7/10/25 passed against the detainee, grounds of detention, information to the detainee, along with all relevant documents were served to the detainee and acknowledged by the same on 10/10/2025, indicating that the documents have been explained to him in Hindi, the language the detainee professes to understand. Further, it is pertinent to mention here that the grounds of detention have additionally been translated to Hindi to enable the detainee to make an effective representation against the detention order, and as such has not fall short of constitutional mandate given in Article 22, Clause 5 of the Constitution.
Why advisory board opinion is not in the file?
Your Lordship, they have said, but the report is yet to be received by the government, Your Lordship. The report is awaited.
How they have acted then?
Your Lordship?
How they have acted on order of confirmation?
No, there's no order for confirmation. This is the first detention order.
Okay, first detention. Because already there is a report.
Here, in this case.
Because Mr. Counsel, we have to see the advisory board report. How you have stated, because you appeared in person before the advisory board.
Yes.
Now, what you have stated, this is a representation which is drafted by council. Right?
Yes.
But how, when you appeared before the advisory board in person, what you have replied? Advisory board is obviously headed by a former High Court judge. So whatever is recorded there, is to be accepted as correct version.
Yes.
It is deemed to be correctly reproduced. If you have stated that I had no problem in understanding the contents of the documents, then language drafted by lawyer would have no value, right?
Yes.
So that is why I started for that advisory board report.
Uh-huh.
It is not available.
But then there are other grounds also. The manner in which the detaining authority exercises subjective satisfaction.
Satisfaction is one.
Yes.
Satisfaction is one. But so far as procedural compliance is the most important thing. Yes.
Yes.
There are varied opinions on satisfaction.
Your Lordship, even my bail applications, they were not considered by the detaining authority, Your Lordship. Here in this case, the rigors of section 35 of the
Actually, the advisory board, what is the subsequent order? Any subsequent order? Latest order? Oh. When it was forwarded to advisory board?
Your Lordship, it's a, page 141, Your Lordship.
140.
So it has been flagged.
Forwarding of. NDP sect. So advisory board has time up to 23rd of December 2025. Right. It may drop or it may confirm. Right. So far as your version would be clear whether you understood the contents or not from your statement made before the advisory board when you are there in person, because you have not said up to what class you have read.
Yes.
You simply said, I understood only Hindi. That, on that assumption, we cannot proceed also. You controvert it first thing by your reply.
Yeah.
And we have time up to 23rd. At least the advisory board is expected
My
quote unquote, to consider the materials on record and thereafter pass an order. Sometimes it is not as per the expectation, the advisory rule, but still we'll consider after that on 14th of January. You file your affidavit in the meantime, because your version before the advisory board, that would be important. So far as constitutional violation of Article 22(5), right? That your hurry, this court has also in repeated cases, a number of cases already said that it has to be not the ground of detention is not only to be explained in the language known to the detainee, but the documents on which basis the detention order has been passed must also be translated in a language with which the detainee is conversant with, right? But on record, to derive that satisfaction, neither an affidavit from your side, sworn statement that I read up to so and so, or the advisory board opinion is not there. So let us have it. You file your reply as soon as that is there, and you place complete records along with the report of the advisory board on the next day, right? But yes, right? Yes. Mr. B. Eden Learned Counsel for the petitioner, and Miss Inaholi. Inaholi.
Yes.
Learned Government Advocate for the respondent number
1 and 2.
1 and 2. Also heard Mr. So-and-so Learned Counsel on behalf of Mr. Yangarwati, Learned Central Counsel for the respondent number 3. First off. An affidavit in opposition has been filed on behalf of the respondent number 1 and 2 today. Post of Mr. So-and-so, Learned Counsel for a petition has submitted that he will file an affidavit in reply on or before the next date of listing. Post of Para. Ms. Inaholi has submitted that advisory board has already rendered its opinion or yet to.
As per the information they've already said, but we're yet to
Okay.
take the copy.
Has submitted the time period for the advisory board to give its opinion is up to 23/12/2025. First off, she has submitted that though she has the records, but the opinion of the advisory board is not part of the records. First off, she has submitted that she would produce the complete records on the next date of listing, list the case on 14/1/2025.
For admission, item numbers 7 and 8.
Before the advisory board, what I have understood. The contents of the document. Then we cannot, our judgment will be wrong. Frankly, it looks like that it has been added. We have to be sure whether he fully understands. Because, like about that man has taken it out. But he is become. So how do we know how does the yeah, the record actually that he is the become. Right. So he cannot take a plea that I don't understand this. And he is not saying what if he is good, he comes up to the graduate. And everything. There's a small statement like that I read up to class 7 when I read it. Yes.
It is my lordships.
Yes, item.
Lordships.
7 and 8.
Yes.
Today, the government advocate was directed to file affidavit.
1 minute, let me read. Appellants are all. Over protection.
It came up on 5th.
Yes. Yes, Zimomi was supposed to file response. State Council, right? Secondly,
Notice. Notice.
regarding private response.
Yes.
What is the rest?
Accepted. Accepted.
Who would accept?
The previous.
Mr. Ponjaran.
Item number 7. I'm accepting notice for some of the respondents.
What is item?
I find my Bangla.
Item number 7. Yeah. Okay, 7.
In the petition for.
How many respondents are here? Where is the memo of appeal?
31, Lordship.
1, 2, 3 is represented by Ms. Sugri.
Yes. Item number 8 and item number 7, his votes at least on his left in another vote. Yes.
He was supposed to file response.
Yes, for that matter, sometime may be given so that we file it after the meeting.
Okay. He represents official respondents. And Mr. Ponji, 4 to 34, you would accept?
Yes.
No, I'm accepting for some of the respondent one, not for all. Not for all.
Then Miss, you are in trouble. You have
No.
to take steps.
Lordship, previously.
No, we cannot force it.
Yes, these are the respondents that I have represented before.
Here it is 4 to 34 are the private respondents.
Yes.
Yes. You represent all or some of them?
28 of them.
28.
How many are there?
Some did not. 31, but some did not appear
Then we have to issue notice.
in the previous writ petition.
We have to still issue notice. You can say let's keep them, we cannot. So if he accepts notice, well and good, otherwise you have to take steps on the remaining respondents.
Lordship, this is the writ petition.
What can I do? What can I do if?
Yes, Lordship.
No, otherwise, madam, looking at the writ petition itself, we can decide on the first day itself. We don't decide.
Of course, Lordship.
For adhering to the principles of natural justice, the other side may have to say something, right? So it is not that notice has to be, that is a procedure, we can't avoid. So Mr. Ponjan, you say which of the respondents?
Lordship,
I'm preparing for respondent number 4 to 8, 10 to 21, 23 to 32. I'm submitting the list.
Yes.
T10 9, then 22. 33, 34.
Investigation.
So 5 of them.
Hmm.
You take steps in the meantime.
Lordship,
All are in college. All are in college, right?
Yes, my lord.
And in the previous proceeding, you represented all or what?
No, I represented
only this, and there was one who was represented by R. Iralu. The four others, they did not, it was published widely in the local dailies, Lordship, but some of them, they resigned also and they did not appear.
So have you asked Mr. Iralu? Yes.
Only one. Yes.
You have no instruction.
There was one that they appeared, one respondent number 9. In the
Right,
previous
but
week.
now she is saying that she has no instruction.
Lordship, can I humbly pray before the Honorable Court? Other writ petitions are, writ appeal are also going to be filed. Since it is so bulky, we could not prepare it for filing at this time. However, by tomorrow we are trying to file all the other writ petitions. There were 12 writ petitions, analogous, Lordship. All passed in a single judgment order. But these are the two. This, it is analogous, but it was delinked from the 12 writ petition. This was 44. Otherwise, all the writ petitions are judgment orders are common judgment orders. And even the judgment order are all the same. Except that it was 144.
Heard Miss, this is item number 44. Item number 44. No, read appeal number 44. Heard Miss J. Chivomi, learned counsel for the appellants. And Miss P. Sufi, learned additional advocate general, on behalf of Mr. P. Jimo Miller, government advocate for the official respondent number 1, 2, and 3. Post up. Mr. Takakichu, learned counsel, has submitted that he has instruction to represent the respondent number 428, 10 to 21 and 23 to 34. 32. Though he has not yet filed the Okalanama on their behalf till date. Post up. As Mr. Takakichu would represent the respondent number so and so. No, before that, issue notice returnable on. Notice was issued? No. Not issued?
No, not issued.
Issue notice returnable on 21st January 2026. As Mr. G. Nomi has appeared and accepted notice on behalf of the respondent number 1 to 3, and Mr. Takakishu would represent the respondent number so and so. Issuance of formal notice to the said respondents is dispensed with. Extra copies of the memo of appeal within how many working days? We have only 2.
We cannot, Lordship. Lordship, I humbly pray that the other petitions are reduced.
You need how many copies? Tell me.
I have received.
I have received. That will be sufficient?
Yes.
No requirement? Yes, Ms. Sukri. Any additional copy you require, memo appeal? How many? How many? You represent 3, so
So,
sir, not required. Not required. Extra copy is not required.
all the issues false.
Huh? As they have submitted that as they have already received the copy of the memo of appeal, no further copy of the memo of appeal is required. We'll record so that process is shortened. Yes, what do you say about filing of response?
Next year.
Before you file it before 18th, we are fixing it on 19th, on or before 19th, you file. We are fixing it on 21st.
Yes, no problem.
Okay. The response from the official respondents shall be filed on or before 19 January 2026. The Mr. Takakishu, representing the respondent was so shall also ensure that its affidavit in opposition, if any, is filed on or before 19th of January 2020. The appellant shall take steps for service of notice. Come.
Just one humble submission. Whether Lordship, other writ appeals will also come, so whether paper publication will be provided, because due to the bulkiness of the writ petition, it will be very difficult to go through registry. And
Here you need 5.
5 in other writ appeals will also come. So
We'll look into it.
Look.
I am looking into only first writ appeal number 44.
yes.
Let us concentrate. Thereafter, we'll go to the next appeal. The appellant shall take steps for service of notice upon the respondent was so and so by speed post within 5 working days from today. So, in the alternative, you keep it blank. You keep it blank.
Just
Keeping it blank. Mr. Jimomi Goido, Sukri. Only with, We are keeping it blank. Here, anybody, private respondents?
yes.
Lordship, I'll accept notice on behalf of respondent number 12.
1 minute.
UGC.
Where is the memo of appeal? Kohima bench. Put memo.
All the parties have accepted.
Chair Jimomi. Appellants, Ms. P. Sukri, learned additional advocate general Nagaland for the respondent number 1 to 4. Mr. I. Jami, learned counsel for the respondent number 12. Miss.
569.
Miss. Hard ekin likhibo to, তাৰপিছত likhibo. Miss so and so, learned counsel, has submitted that she would appear for the respondent number 5, 6, and 7. 5, 6?
6 and 9.
5, 6?
5, 6 and 9. Yes.
9.
Yes.
Okay. 7, 8, 10, and 11. Your problem is solved, madam.
Yes.
Why you are submitting? Why you are submitting your paper publication for all the? Everybody is represented now.
Yes,
Miss so and so, please,
in other writ,
would represent the respondent number so and so. Huh? Issue notice returnable on so and so. Huh? As so and so is represented, issuance of formal notice is dispensed with. You need copy of the memo of appeal? Huh?
already.
You have received, you have received, you have received, you have received. So same state. So all are represented?
Yes, Lordship.
All are represented. Then the respondents will ensure that their counter affidavits. Okay, okay. Ms. Sukri, additional Advocate General appearing for the respondent number 124 has submitted that the affidavit in opposition filed in the writ petition would suffice, and the state is not going to file any further counter affidavit in this appeal, right? Yes, others. Okay, the learned counsel appearing for the other respondents have submitting in similar lines have also submitted that no counter affidavit is going to be filed on their behalf. Right? No, I'll come back to you. I'll come back to you. List this appeal along with writ appeal number 44 on 21st January 2025. Right? Hold. 45 is okay. Everybody is represented. Right. Let us come back to 44 again. Yes. For the remaining 5, what do you want? Paper publication.
Paper publication.
Huh? Or dusty?
Dusty also.
5. Only 5.
Yes, Lordship.
Others are represented.
Paper publication will be more convenient, Lordship.
Then it would go beyond 21st. Because holidays.
Yes.
Then they have to be given some time for appearance also after paper publication.
It's okay, Lordship. It's okay.
Then all the dates are to be corrected, not 21st January. It would go to 7th in February. 11th of February. Both are 11th of February, right? In the alternative, Miss Jimomi has submitted that the appellants may be permitted to serve the notices upon the remaining respondents in the substituted manner by way of paper publication. First off, the prayer for service on the service of notice upon the remaining respondents in substituted manner is allowed. First off, it is therefore directed that the appellant shall publish the notice in 2 English daily newspaper having wide circulation in the localities in the district where the remaining respondents are located within a period of 4 months, indicating in the notice that the date of hearing has been fixed on 11th February 2025. So after publication of the notice, the appellant shall file a compliance affidavit to that effect with the original copies of the newspapers where the notice has been notice is published. The process is to be routed to the registry of this court. Baki upor line continue regarding stage-wise speed post. Is the case on 11.
Lordship, I also have prayed for staying of the impugn judgment order only on two issues. I
is dismissed, how can she pray for staying?
Oh, dismiss.
Lordship dismiss on maintainability, and I'll explain that. Lordship, I'll just.
No,
address
it
my
is
lordship.
difficult, it is difficult. If it dismissed on maintainability, now stay of the judgment. What stay of the judgment?
Yes.
One, just
Think it logically and legally. If the petition is dismissed,
Yes.
so everything is zero. If it is zero, how can we stay zero?
No, just one aspect.
It is a vacuum now.
Yes, Lordship, I admit. But just one aspect, Lordship. Here.
Shall I record? Shall I record that you asked for a stay of the judgment? And on noticing that the petitions have been dismissed on the ground of maintainability and locus, and so interim prayer is rejected.
Lordship,
Better.
on the issue, just, my lord may not interfere, but just on one issue about my locus. Here, the learned civil judge has passed passed the judgment order on the issue of locus that I have been declared that I don't have a locus. Then, on the other hand, I am asked to file separate writ petition of each petitioner, each respondent. That is one issue. And here, if we go by this logic, none in Nagaland now, the educated unemployed have the locus anymore, and all the department infested with backdoor appointment, none will be able to challenge because the locus saying that I have to have requisite qualification at the time when the respondent were appointed, and they were without qualification.
Madam,
Yes, Lordship.
on those two grounds, the learned single judge
Yes,
might have
yes,
dismissed your writ petition. So before entering into the merit of the writ appeal, as well as in the writ petition, we have to overcome those two grounds,
Yes, Lordship.
and thereafter we have to enter into the merits.
Of course.
Right. So this also needs the hearing at the final stage.
Yes.
We are not deciding it. So how can we stay the judgment?
It's only about the locus, Lordship in general.
Madam,
principle. Only on the issue of locus.
Okay,
That has-
then if you're insisting, we are hearing, then let us have your interim prayer. I have indicated to you, now let us see the judgment. First, let us see, do we have an interim prayer?
But
Let us have it on merit.
in the late, yes, Lordship.
Let us have it on merit on the interim prayer.
Yes, Lordship. 144, Lordship. My lord is on the.
No, let us,
Main
no, read appeal first.
Lordship, the last.
No, in the memo of appeal first, let us see.
Yes.
You have IA.
I have Lordship. Just on the locus, Lordship. This has kept the whole state employment. If my lord, we kindly come to 608 page. Lordship, we kindly come to page 37. Allow me to read out one here.
No, let us see the IA first. What you have contended. Okay, where is the judgment of the learned single judge?
In the IA page 38.
In
In the
the
IA, yes, I have an exhibit in the IA worksheet. Page 12 of the IA. The operative portion is, I am referring to, starting from page 37. Page 37. Paragraph 37. Allow me to read out worksheet.
IA number?
IA number 44.
Huh?
234. 234.
234, 234.
Yes.
234.
April 44.
IA number 234. It is there perhaps.
Page 37.
37.
Paragraph 37. 37, it says, Lordship. At this juncture, the court will examine the question of maintainability of the writ petitions, as this ground has been raised by all the private respondents. The court has observed that, except petitioner 3 and 5, none of the petitioners were qualified and eligible to be appointed as lecturer assistant professors at the time when the private respondents were engaged on fixed pay. In the case of B. Srivastava Reddy versus Karnataka Urban Water Supply and Drainage Board Employees Association and others reported in 2006-11 SCC 731-2. The apex court held that a writ of certiorari cannot be issued on the behest of a person who himself is not unqualified. 38. The petitioners have also not filed any reply to the affidavits filed by the respondents, which will imply that the statement made in the counter affidavits are not controverted. The respondents have stated in their counter affidavits that since their service have been extended from time to time since their first appointment, however, extension orders which were issued after the petitioner became eligible have neither been brought on record nor challenged except one extension order dated 4/7/2022. The notification dated 4/7/2023, by which the service of the private respondents were extended, is not under challenge. All these are under challenge, Lordship. It is a misnomer. The latest extension order of the private respondent by the number so and so dated 17/7/2025 is also not essayed. It is essayed herein, Lordship. The parties to the case are bound by their pleadings, and particularly in a writ proceedings. Pleadings are important as the dispute has to be decided on the basis of the affidavits filed by the parties. The discrepancies in the writ petition render the writ petition defective and not maintainable. 39. The court requires a single cause of action on related cause of action for each petition. And further, all the petitioners should possess the locus standi to sustain the challenge to the appointment of the private respondents. If a person contains several different distinct causes of action, the petition cannot be maintainable. Separate writ petitions have to be filed in order to prevent judicial efficiency and confusion. If one or some of the writ petition lack locus, the petition is liable to be dismissed. 14. In view of the above reason, this court is of the view that the writ petition is not maintainable in the present form, and there is no scope for into the merit of the case. The writ petition is therefore dismissed on the ground of maintainability and locus standi. However, the petitioners are given liberty, if so advised. Before parting with the reports, this court has taken note of the fact that contract interim arrangements are being continued till date. It is expected that such interim arrangements should not continue indefinitely, and the state respondent should take a call in the matter with regard to creation of posts of assistant assistant professors, and upon being created, the same should be filled up by the following due process of law. The writ petition stand discourse of interim order if any stands merged with this order. So this is the order passed, and my lord, if we go by this proposition, lordship, none of the
So if we stay this order, suppose on the ground of mentality, writ petition was not entertained, right?
lordship,
Whatever, right or wrong, that is a defined issue. Secondly, the second part of the judgment,
yes, lordship.
that interim arrangement to continue with the private respondents indefinitely,
Yes, lordship.
that part will also be stayed. So by virtue of this interim order, they would continue. Right, indefinitely. If you press for a stay order. Right. Right.
Lordship.
And next, the state government was directed to take a call for creation of post of assistant professor. Upon being created, the same should be filled up by following due process. So that will also be stopped. So by virtue of this stay order, that interim arrangement going on indefinitely, that would be continued. In my little and limited understanding. And state government will be stopped from creating new post of assistant professor and to fill up the post in conformity with Article 14 and 16 of the Constitution of India, right? Which is not permissible, at least for a court like us. Heard.
The
Heard.
complicated thing is that locus of the
No, this will be decided. You court has tentatively viewed, but this will be decided. That is a final judgment, madam. Do we decide on the first date? And what you are asking for something which is against Article 14 and 16. The Ranjit Singh has said, please discontinue the practice of engaging in ad hoc assistant professor indefinitely, and please create post. That will stay the whole part.
lordship, if you are to go by that, on 16/6/16, on oath, then a contract appointment was placed before this honorable board by the state respondent. The next day, even before this court,
Heard,
anyway, at least my lordships.
J. Jimomi, Learned Counsel for the appellant. Mr. J. Jimomi, Learned Counsel for the Learned Government Advocate, Nagaland, for the opposite party, does respondent number 1 to 3. And anybody, Mr. Taka Kichu. Learned Counsel for the opposite party get লিখিব কাগজখন আছে না কাগজখন পাইছে না এখন First of all, the instant interlocutory application is preferred by the applicants seeking a stay of the impugned judgment and order dated 12/11/2025, passed in the writ petition WBC number 340/2022. First of all, the applicants as the writ petitioners had preferred the writ petition WBC number 340/2022. Stating that they are master degree holders and net qualified candidates in their own subjects. First of In the writ petition, they challenge the appointments of the private respondent number 4 to 34, who have been implemented herein as opposite party, as respondent number 4 to 34 in the writ appeal, in the accompanying writ appeal, as assistant professors, allegedly through backdoor without advertisement in violation of the office memoranda, various office memoranda posted. Where the learned single judge had, however, dismissed the writ petition, observing that the writ petition contains several, distinct causes of action, and therefore the writ petition cannot be held as maintainable. Full stop. The learned single judge has further observed that separate writ petitions ought to have been filed with an observation that if one or some of the writ petitioners lack locus, the petition is liable to be dismissed. Post of learned single judge has further observed that out of the writ petitioners, only 3 of the writ petitioners were having the qualification when the opposite private respondent number 4 to 34 were appointed or allegedly through backdoor.
Unqualified.
Allegedly through backdoor, and that too, when they lacked the essential qualification. Post of the learned single judge has further observed that while dismissing the writ petition on the ground of maintainability and locus, has further observed that the petitioners have the liberty to file appropriate and separate writ petitions in accordance with law if so advised. First of the learned single judge has further observed that the contracts from interim arrangements which are being continued till that date should not be continued indefinitely, meaning thereby the interim arrangements should be stopped. Post of the single judge has further observed that the state respondents should take a call in a matter with regard to creation of post of assistant professors, and upon being created, the same should be filled up by following due process of law. Post of if the learned counsel for the applicants has pressed for a stay of the impugned judgment and order dated 12/11/2025. Post of if a stay on the impugned judgment and order, if a stay order on the impugned judgment is passed, the state respondents would be provided with a liberty to continue with the interim arrangements of continuing with the assistant professors who are allegedly lacking the essential qualification, and the state respondents should also be stopped from taking any decision to create the post of assistant professors and to fill up the created post by following due process of law. Post of the petitioners, the applicants, the writ petitioners, that is the present applicants, appellants, are aspirants for filling up of aspirants for assistant professors for the post of assistant professor. And assistant professors on the ground that they have the essential qualification. Full stop. Having regard to the principles embedded in Article 14 and Article 16 of the Constitution of India, vis-a-vis the content, the prayer for stay, this court is of the considered view that the stay of the entire judgment, entire impugned judgment and order dated so and so passed by the single judge is not called for. First of the issue regarding the lack of locus standi issue regarding maintainability of the writ petition and lack of loci standi, lack of locus of the writ petitions can also be can only be considered at the stage of hearing of the accompanying writ appeal, wherein notice has already been issued by an order passed today. In view of both the instant interlocutory application seeking stay of the impugned judgment and order dated so and so is dismissed. Same order in the other one.
The other is that perhaps the product is supposed to have the notification.
Okay, now you delete that part. You delete that part. Qualification and allegation asana. Lacking qualification, that part you delete.
For admission, item number 9.
Three writ appeals lordship because
Lokaयुक्त.
three different writ petitions have been filed. In the first writ petition, the petitioners have challenged the determination on the ground of non-affording opportunity have been heard. So that has made the government more wiser to issue show cause. So they have revoked the termination order and issued the show cause notice. That was challenged in the second writ petition, which is writ appeal number 42 of 2025. And the last one is a person who has missed the bus along with the first batch. She has joined. So she did.
Basically, interpretation of the Lokaयुक्त Act.
Exactly, Lord.
Right. Otherwise, show cause notice is not to be stayed, not to be stayed. So what I think, propose subject to my brother, that you reply, but no final decision. No final decision regarding that this show cause notice otherwise is not to be stayed. Regarding section 9, some hearing would be required whether the single judge was correct or not. That part would require some hearing from your side, from their side.
But is subsequently the ultimate point is whether the Lokayukta has the locus standi or not. And when that point is raised,
Everything will go.
yes, if they don't have the jurisdiction, everything will go. That was the basic point to have challenged in the writ petition. Otherwise.
So learned single judge has held that he has the power.
Yes.
So you are sailing against that.
The ground
So-
of challenge is
Ah.
on what basis? Because the finding of the learned single judge was arrived on the ground that, look, there are two types of grievances under section 9. If the complaint is with a grievance by the person.
Complaint
concerned-
and complaint with a grievance.
Yes, with a grievance, then the Ayuktha will not have the jurisdiction. But if it is filed by a third party, making an allegation, such cannot be attracted the bar under section 9. That is the sole point to be determined by the honorable.
That is a possible view. There could be another view.
Yes. Now, the only question is, on what basis the learned single judge has arrived to the conclusion that it is a complaint by the third party and it is only a mere allegation. Because Lok Ayuktha did not contest the case. From where the learned single judge has arrived to that conclusion. That is the sole issue. We have asked for a copy of the complaint through RTI. Lok Ayuktha said that no, you are not entitled for a copy. So we do not know whether it is a grievance with a grievance only. So from where the learned single judge has arrived to the conclusion that it is an allegation and a complaint by third party. From where?
Which paragraph?
Lordship, may kindly come to paragraph 14, page 136, 35. Paragraph 14, page 135. I'm voting 42, Writ Appeal 42 of 2025.
41.
Because 42 is the case where we have challenged the show cause proposal. Page 135, paragraph 40. This is his finding, Lordship.
Paragraph?
Paragraph 14. Where it, Lordship. This court, on perusal of the provisions of subsection 1 of section 9, did with the said provisions of clause D of the second schedule, is of the considered view that the bar contemplated under section 9 of the Act of 2017 cannot be extended to an allegation by a third party with regard to the allegations of the corruption and respect of opponents. This will be very important. I'll come back later. The complaint involved in the present matter relating to the investigation carried out by the Lok Ayuktha Nagaland, concluding in the advisory issued by order dated 16/7/2025, is an allegation labeled by a third party, and the same was not in connection with any grievance raised by him in the matter.
You want to say that this complaint was not available before the learned single judge?
Yes. Yes.
So it is not possible for him to say that it is either a complaint or a grievance.
Yes. Whether a grievance is involved or not, it is not. But to our information, one of the landowners, he was not appointed. So with that.
That is a grievance.
He has filed a complaint.
So the complaint is with a grievance.
Yes.
That is your case.
Yes.
If that is so,
Yes.
then learned single judge's view, what is complaint and what is grievance?
Yes.
The grievance will be attracted.
Yes.
Not complaint.
Correct. Doctor.
We don't know. So what to do? Yes.
Your Lordship, only one thing I just wanted.
You were there in the writ proceeding.
Yes, I was representing
Ah,
the state, Your Lordship.
So what Mr. Jameen is saying, that complaint was not on record.
Yes,
So it was not possible to decipher
yes,
whether it was a complaint by third party or a complaint with a grievance
Yes.
regarding non-appointment.
yes,
If it is a complaint with a grievance regarding non-appointment, then as per the learned single judge's own interpretation,
yes,
the Lokayukta would be debarred from proceeding further. Is it not?
Yes.
This is your case.
Simple case.
Simple case.
But only one thing, if I may be allowed to take my lord to page 48.
No, fact of the matter is whether a complaint was before that let us single judge or not, we are only on the matter of admission and the prayer for interim relief.
Yes.
So,
As far
I
as
think that we
complaint-
only consider
Yes,
whether the complaint,
yes,
the supposed complaint,
yes.
was before the let us single judge or not.
Your Lordship, one record was available before the single judge, Your Lordship, is at page 48, where the order of the local the order was passed by the local in the first para, Your Lordship. In the first para, there is that starts with the Nagaland local, Your Lordship. If I may be allowed to read just this para.
Page 48.
Yes, page 48 of the yeah, of the appeal memo.
Apple memo, all right.
Yes,
It is a
yes.
type copy.
Yes.
Ah,
Your Lordship, here, my copy is
Is holding another call.
no, read April 3.
read appeal 42.
Yes. In the BPC 3.
You to tally, then say us. Hmm.
My copy, yes, the Lordship. My copy, I wanted to refer from the writ petition that is referring to, but here my copy is actually not legible at all. In my copy, and there's no type copy index. I was referring from the other, the Lordship. But if I may be allowed to read this, just allowed to read this.
Page.
Page 53 then, ma'am. Just the first paragraph. I may be allowed to read this.
Hmm.
The Nagaland local authority received a complaint filed on 10/10/2022 against the Department of Employment, Skill Development and Entrepreneurship, alleging that the bogus appointment was made to 12 posts of multitasking staff for brevity. Hearing after referred to an MTS in the year 2022 without obtaining government approval and in violation of the laid down government procedures regulating such appointment, and further that the appointment was made prior to the lifting of the ban on such appointment. The allegations made in the complaint by the complainant has been examined. So there was an allegation. I just wanted to read this to my doctor.
Let us, where is the Lokaयुक्त Act otherwise? Lokaयुक्त Act?
Act.
Act. Matter needs some consideration till that. Let us see.
It is reflected in the judgment also. The relevant.
Which is the section otherwise?
provisions are reflected.
Heard Mr. C.T. Jamil and counsel, senior counsel, established by Mr.
And I entered.
Land counsel for the appellants and Mr. N. Angami, land government advocate for the
Lordship, I'm for the respondent.
deputation of section 9. So, for the time, I allow. Suspended to the disposal of the because it will differ about that. It's It's true. Because if you do not stay, then appearing in the time of the session. For all the respondents, Mr. Mujib, Angami, for all the respondents.
No, Your Lordship, I'm not for Lokaयुक्त.
Lokaयुक्त is not a party here.
No, is not.
Yes, Your Lordship. Not in this.
For all the respondents.
Yes.
It's on termination.
Huh?
Show cause.
Okay, this is 42, huh? Read appeal number 42. Huh? 42, huh? issue notice returnable in 4 weeks as Mr. Angami, learned government advocate, has appeared and accepted notice on behalf of all the respondents, issuance of formal notice to the said respondents is dispensed with. However, the learned counsel for the appellates shall furnish requisite number of extra copies of the memo of appeal to Mr. Angami within 3 working days from today. We'll pass the order in the I.
Not two.
Okay, 41. 41.
In the other two cases, Lokayukta is respondent number 2.
Same city, Javin, listed by so and so. Mr. N. Angami, learned government advocate, Nagaland, for the respondent number 1, 3, and 4. Post of issue notice returnable 4 weeks, as Mr. Angami has appeared accepted. 1, 3, and 4, issuance of formal. The appellant shall take steps for service of notice upon the respondent number 2 by registered post by speed post with ready within 2 working days from today. This is writ appeal number 41. Then writ appeal number 43. Single appellant? Single appellant?
Yes.
Appellant. And Angami, 1, 3, and 4, same, First of all. Okay, what is the I in 42? Writ appeal number 42. What is the I number? 231. Third, Mr. C.T. Jamit, land senior suggested by so and so for the applicant's appellants. And Mr. N. Angami, learned government advocate for the opposite party, for all the opposite parties, stroke respondents. Post of the Eastern interlocutory application is preferred by the applicant's appellants seeking a stay, praying for an interim order in the form of suspension of the impugned judgment and order dated 24/11/2025, passed by a single judge in a writ petition WPC number 17/2025, which has been the subject matter of appeal, which has been the subject matter in the accompanying writ appeal number, writ appeal number 44. Sorry, 42. 42/2025. Postal. The learned single judge has observed that the learned lokaयुक्त proceeded on the basis of a complaint dated 16/7/2024. You just read that order at page 53. What is the complaint date?
No, 10/10/2022.
10/10/2022.
Yes. That's good. That's correct.
10/10/2022. First of after having considered the provisions of section 10 of the Nagaland Lokaयुक्त Act 2017, the learned single judge has observed that there can be 2 kinds of complaints. Namely, firstly, italics. a complaint involving an allegation which can be raised by any person, semicolon, and secondly, comma, a complaint pertaining to a grievance which is to be raised by a person aggrieved. Full stop. Having noticed that the lokaयुक्त, the complaint, having reached a finding that the complaint before the lokaयुक्त was one involving an allegation which can be raised by any person. The learned single judge has proceeded to observe that such a complaint can be inquired, investigated into by the lokaयुक्त, and necessary direction can be passed. So Mr. Jamir, now senior counsel appearing for the applicant's appellant has contested that the complaint on the basis of which the lokaयुक्त had proceeded with was not even before the single judge, and as such, the reaching the finding by the learned single judge that the complaint was one involving an allegation raised by any person is not on the basis of materials on record. So he has submitted that the complaint appears to be one which has been lodged by a person, by disgruntled complainant after his non-selection, right? Non-appointment, full stop. Having regard to the provisions of the so-and-so lokaयुक्त Act, this court is of the considered view that the provisions of Section 9 needs would require a consideration to arrive at a finding as regards correctness or otherwise of the impugned judgment and correctness and otherwise of the findings recorded by the learned single judge. Full stop. As disciplinary proceeding against the appellants is being contemplated, comma, this court, comma, to balance the equities, comma, is of the considered view that till the disposal of the accompanying writ petition, comma, the impugned judgment, operation of the impugned judgment and order dated so shall remain suspended. It is accordingly observed. Post the interlocutory application. It is accordingly observed by allowing the instant interlocutory application. Same order? Same order in the other IE?
Yes, not so.
All are contemplated for disciplinary proceedings?
And in 41 and 43, we will be allowed to take steps by a registered post on the lokaयुक्त.
Now it is in the speed post. I have already ordered.
Yes.
I have already ordered.
So fast.
Lokaयुक्त. Only some oxygen is given. Whether oxygen would continue or not, we don't know.
As an employer, we are still and. Give me a pleasure.
Oh, yes.
Allow me to make a mention. If you are different pay system, we'll tell you that you are updating. This morning I had said a mention for listing one method and this honorable board has allowed for listing it tomorrow. However, my learned friend is not available tomorrow. I know. So that can be taken up today as well as.
My brother has a single bench also.
Yes, my lord.
So how many meters?
4, 5, 3, 4. Okay.
We are up to 11. So
6.
how many meters are there?
6 plus 1 is
Okay, we'll take up. We'll take up.
Your worships.
Yes.
Your worship, we see your indulgence, item number 23, the last item.
Oh, yes.
This is a review petition, your worship.
Review petition.
Yes, your worship.
Yes,
Since
yes.
the judgment where the worship was sitting in the then of the chief justice.
Okay,
This is about the east-west corridor.
okay.
So there's an IA also, your worship, there's a delay of 323 days.
We have to issue notice.
Yes. That's why I sort of mentioned because there's some other matters which may be heard. Then my lord has a single bench.
No, let us go continue. Seriously.
Very good.
Seriously. You have any urgency?
No.
For admission, item number 22.
Yes, Mr. Jamir.
Yeah, this lordship,
What order you are challenging?
lordship, this is order, judgment order dated 6/11/2025.
Yes.
Pass and petition for 2021, the lordship.
In order is cost and set aside.
Also, the issue involving this for determination in this appeal, your lordship, is whether an application under Article 226 for a writ of certiorari will die against the order passed by Deputy Commissioner of Dimapur on the revenue side, sitting as a court under Assam Land and Revenue Regulation in 6, lordship.
Whether he has an appellate authority
There is no
under the Assam Land and
Land
Revenue
Revenue.
Regulation 1886.
no,
Board of Revenue, just like in Assam.
no, your lordship.
No.
But then here in bias for submission, if at all the petitioner is to approach, it can approach under 227 or go for civil suit as held by a division bench of this honorable court in Bangladesh.
That would require examination.
Yes, your lordship.
Will issue notice.
Lordship.
Heard Mr. TB Jamir. Yes. Issue notice at least.
Yes, right.
Heard Mr. TB Jamir and it counsel for the appellant.
I will not pray for any interest.
Yes, yes. Appellant. So many private respondents. Many private respondents.
Yes, your lordship.
Okay.
And if your lordship may kindly see.
And who are the official respondents?
There were petitioners here, opposite party 1 to 72.
Okay.
Your lordship may kindly see the.
Who is the state council?
Oh, this case coming in.
Yes, Mr. N. Angami, land government advocate for the respondent number 73, 74, 75.
75.
Correct.
Okay. And this intercourt appeal is directed against a judgment, an order dated 6/11/2025, passed by Lawrence single judge in a writ petition, WPC number 42/2021, whereby the writ petition preferred by the respondent number 1 to respondent number 72 as writ petitioners has been allowed. Poster. The Lawrence single judge has set aside an order dated 11/2/2021, passed by the respondent number 75.
5.
And the parties are posted. The Lawrence single judge has, however, directed the parties to maintain status quo over the suitland till such time either party approaches a competent civil court for declaration of the right, title, and interest in respect of the plot of land in question. Post of Mr. Jamil and counsel for the counsel for the appellant has submitted that the order dated 11/2/2021 has been was passed by the respondent number 2 acting as a civil court, and as such, the writ petition under Article 226 of the Constitution ought not to have been entertained. So it is his contention that the response number 75, the order dated 75, order dated so and so passed by the response number 75 as a revenue code is deemed to be an order of the civil court.
There's no quasi-judicial order.
Okay. No, or a quasi judicial order. And against such order, only a petition under Article 227 of the Constitution of India, or Constitution could have been preferred. The matter would require consideration, issue notice, returnable in 4 weeks, as Mr. Angami has appeared, accepted an extra copy within 2 working days. The appellants will take steps for service of notice upon the response number
1 to
72.
Your Lordship, address given by, this is the address given by the petitioner and the writ petition, accordingly I have given your Lordship. The address your Lordship Mehta is in page 2.
On Purana Bazaar, B village.
The address is so vague, your Lordship.
Ah.
Even if I take step, I don't think it will go, your Lordship. So.
No, but we have to mandatorily follow that. You first take steps.
I think it would be a futile exercise, your Lordship, because no proper address, no house number is given, your Lordship. Your Lordship, you can just say page 2.
I have seen.
Your Lordship.
How big is the Purana Bazaar B village? And what is the plot of land? What is the area of the plot of land?
It is covered by pattern number 104 and area is 34 bighas.
34 bighas is not that much.
But in total area.
It must have pin code. You find out the pin code. You find out the pin code of Purana Bazaar and incorporate. Thereafter, we will proceed. Paper publication. But paper publication is substituted manner. That is not the first step.
Then, your Lordship, can I give it care of village council, German village council? That will be more.
No, that may be a next step.
Lordship?
That may be a next step. If something returns, if one gets, everybody will come.
No, your chairman.
Is it not?
You know, the German village council from the party here, 76.
It will be because had it been Mr. Angami, I could have said that yes, let the official serve the notice. But village
Because
council,
you want to ensure that effective service is done, your Lordship.
as I have found, village council is a body which acts on its own.
Now, he's from the party here, your Lordship.
In the state of Nagaland. So I'm not accede to your prayer on the first date itself.
Lordship.
And also 1 to 72 and 76
Yes.
by speed post. Within 7 working days from today. Then you make a prayer.
Lordship. Right. Okay.
For orders, item number 12.
Kim?
What's we have has already been approved for the last application. And the LCR is here.
This is item 12.
12.
Preparation of the demo.
12 is what? Appellant has not
Will not review,
taken.
my lord.
You have not taken steps. Response number 2.
I'll take it
Office note
immediately.
says,
I'll take it immediately, that yes.
Ah.
Myself.
is it POXO?
No, my lord. This is not also. This is. Please don't do, my lord.
302.
Yes, my lord. Let me see.
But court directed earlier,
Yes, my lord.
you take steps.
My lord, my lord. I'll do it immediately.
Okay, hard Mr. Senti Angle and counsel for the appellant. Full stop. Here is the office note dated 8/12/2025, which has reported that the appellant or appellant's high logo? Single appellant.
Yes, single appeal, my lord.
Which has reported that the appellant has not yet taken steps for service of notice upon the response number 2.
Yes, perform our company.
Mr. Santiago has submitted that he be granted 3 days time to take steps upon the respondent number 2.
My lord, I am told that steps have already been taken and the reports receipt is also there.
Has submitted that he has submitted that he has already taken steps for service of notice upon the respondent number 2, and he has the requisite postal what is
Postal
that?
receipt, my lord.
Postal receipt. Post of Mr. Sentianga shall submit the postal receipt before the registry, and the registry shall in turn ascertain the status of service of notice upon the respondent number 2.
My lord.
Post of as okay. Issue a reminder for the TCR. Oh, receipt. As the TCR has been received, comma, the registry shall prepare registry to take steps for preparation of the paper book. Release the case appeal after 4 weeks with a report as regards service of notice upon the respondent number 2 and a report as regards progress made in respect of the service book.
Thank you, my lord.
For orders, item number 13.
Yes, heard Mr. Moajami, learned counsel for the appellant, and Ms. Livika, learned public prosecutor for the state, respondent state, post of. Where is the office note dated 8/12/2025?
Yeah, but that the informant has already expired, so.
Okay. Which has reported that service report in respect of respondent number 2 is awaited. First of Ms. Livika, public prosecutor has submitted that the respondent number, what is the offense?
Lordship.
Offense, conviction.
Section 4(2) of also.
4(2).
I got the information from the petitioner only, not from the IO, I mean, not from.
Oh, it should be from the IO,
Yes,
not from the appellant.
No, since the.
No.
That's why, but since
No.
this was not complete.
I thought that you got the
No.
instruction from the
That's why I-
officer in charge.
Make me clarification.
You get the report.
Yes.
Mr. Moajami, learned counsel for the appellant has submitted that he has learned that the respondent 2 has already expired. To stop. Ms. Livika,
In fact,
learned
number 2
public.
is being completed also.
Huh?
Number 2 is not being completed.
Yes.
Court has proceeded on the basis that in POXO case, it is always the informant or the guardian or the victim
Lordship.
is mandatorily to be made party respondent number 2.
Yes.
You have not made,
Yes, Lord.
but court has, without looking at the memo of appeal, because
There were some.
the practice prevalent in the principalship.
Yes, Lord.
Informant is filed,
No, informant is not made
In
party.
fact,
not made party.
he expired in year 2021, Lordship, before he was examined, Lordship. Even in the trial.
Victim at fire, not the
Victim
father.
is alive.
Victim is alive.
Okay.
What is the practice direction? We have a practice direction of the Gauhati High Court,
Lord.
where the victim
Lord.
or his parent
Lord.
or his guardian or his support person is to be made respondent number 2. Even if the informant dies
Lord.
and who is not the victim,
Yes.
victim is alive,
Yes, Lord.
so victim may come,
Yes.
or victim with a support person might be mother, the guardian might be mother.
Lord.
Yes.
The victim should be represented.
In that case, Lord, why we are allowed to take necessary steps to impede,
X.
You better take necessary steps. How long? 20 years. So you have time.
changes.
Okay, Mr. Moajamir, father died recently. Mr. Moajamir, learned counselor for the appellant, has submitted that he has information that the father of the victim who was the informant, has expired. Full stop. He has, however, submitted that he would make endeavor to implead the guardian of the victim as a party respondent number 2 in this appeal by appropriate pleading within 2 weeks' time. Right? Within 4 weeks' time. Within 4 weeks' time. Okay. Peruse the office note dated 8/12/2025. Post up. Issue a reminder for the TCR. Release the case after 4 weeks.
For orders, item number 14.
Yes, how much delay?
196 days, my lord.
196.
Yes, my lord.
And what is the offense?
364.
Three?
For ransom.
364.
A, IBC.
Kidnapping for murder.
For ransom, my lord.
Ransom.
Yes, my lord.
Conviction?
Imprisonment for life, my lord.
Okay. Miss Libika? Delay. IPC offense. Wait.
Yes. Okay, otherwise get changed. Maybe if they want to. Okay.
It's fine. Life imprisonment.
Fine. Okay. Yes, right, up to once. Yes.
Heard Mr. Santiago, learned counsel for the appellant, and Miss Libika. You are legal aid counsel?
Yes, my lord.
Okay. Learned legal aid counsel for the appellant, and Miss Libika, learned public prosecutor for the respondent state. To establish an application under Section 5 of the Limitation Act 1963, seeking condonation of delay of
196 days.
196 days, which period of delay has occurred in preferring the accompanying criminal appeal under Section 415 Bharatiya Nagorik Surakha Hanita 2023 against the judgment. Where is the judgment?
Judgment is dated 18/3/2025. Page 9, my lord.
Post up.
And the sentencing order is
Post up. The applicant as the appellant has preferred the accompanying appeal against a judgment dated 18/3/2025 and an order on sentence dated 24/3/2025 passed by the Court of Learned Principal District and Sessions Judge.
Dimapur, my lord.
Dimapur, it is not mentioned. Dimapur.
Yes, my lord.
In, what do you say, Sessions case or ZR case? ZR case.
Yes, my lord.
It is not registered as Sessions case.
Yes, it is GR.
Okay, in ZR case number 485/2018. Full stop. By the judgment dated 18/3/2025, the appellant, who was one of the 4 charge-sheeted accused persons, who as one of the four charge-sheeted accused persons stood the trial, has been convicted for who is the operative part?
Lordship, page 38. First paragraph, my lord. This court thereby sentenced the convicted person so and so to undergo life imprisonment and to pay a fine of rupees 10,000 for committing offence under section 364A IBC. That's the clear, my lord.
So this page 10 is misleading. Page 10 is misleading.
That's clear, my lord.
Page 10 table convicted. Okay. Okay, there is gap. Has been convicted for the offence under section 364A Indian Penal Code. And by the order of sentence, he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, without default stipulation.
My lord.
Huh?
Yes, my lord.
Okay.
It is optional.
No, no different.
We have gone through the statements and environments made in this interlocutory application. More particularly, paragraph 4 thereof. Full stop. For paragraph 4, it can be noticed that the matter has been assigned to the assigned by the Nagaland State Legal Services Authority to the Learned Legal Council only on 14/8/2025, and accompanying bill has been filed on 30/8/2025. So stop. Having gone through the statement and environments made in this application, we are of the considered view that the applicant has been able to explain the delay showing sufficient cause. Ms. Libika, learned public prosecutor has submitted that since you are submitting anything? No.
It concerns the deputies.
Has submitted that as the petition appellant has been convicted, has been sentenced to undergo imprisonment for life, the accompanying appeal can be heard on merits. Having regard to the regions assigned, explaining the delay, no, in any view of the matter, we are the considered view that since the appellant has been sentenced to undergo imprisonment for life, the accompanying appeal is required to be heard on merits, leaving aside the period of delay, considering the delay, which is not substantive and which has been explained. Accordingly, the instant interlocutory application seeking condonation of delay of 179 days is allowed. The registry to register the accompanying already registered. Register the accompanying criminal appeal and thereafter to release the case for admission. Tomorrow we are not sitting, no? Otherwise you could have notice. Right. Tomorrow is the petition.
LCR can recall.
No, this
and take care of it.
For orders, item number
they have to
16.
release the criminal appeal in the next division bench. I don't know what is the list. If it is listed tomorrow, we'll admit. Right.
My lord. Right.
Yes, madam. What is the issue about? Notices issued by Dusty as well as Speed Post. Return service memo awaited. Yes. Do you have anything on Dusty service?
Contact the client as well as.
Okay. Miss
Proceeding.
Learned Counsel for the. This is for what? Condonation. Hmm? Oh, condonation. This is a read appeal So private persons are involved, unlike criminal appeal, so we have to wait. Miss Esther for response number 2. Miss Libika for government advocate for response number 1. Election tribunal? No. But on the earlier date, the Government Council accepted notice for response number 3. For the response number 1 and 3. Who is response number 4? Private person. Post of Miss So-and-so, Learned Council for the applicant, huh?
Ownership election company would have their own standing council or federal.
Oh.
I think.
On the previous date, I don't know, Miss Bichano Kithan accepted notice, the Government Council accepted notice for 1 and 3. Who is the?
My colleague,
Who is the standing council?
they have
Okay.
ascertained from the consent department.
Okay, uncle. Baki take Miss Livika, Learned Government Council has submitted that on 13/8/2025, the Government Council, Learned Government Advocate accepted notice on behalf of the response number 1 and 3. But, to her knowledge, the response number 3 is to be represented by its Learned Standing Council. Still, Mr. Vika has sought time to sought further time to apprise on the matter, on that aspect. Miss So-and-so, Learned Council for the applicant has sought time to obtain instruction as regards service of notice on the response number 5 by way of Dusty, and to submit an affidavit to that effect within 3 weeks' time. Within 4 weeks' time. After the ensuing notification. First of, raise the case on a date after the ensuing notification. Post of, the registry shall furnish a report as regards service of notice upon the response number 4, which was taken by the applicant through speed post.
Orders, item number 23.
Yes. Seeking review
Yes, sir.
of a judgment, okay, where I was part.
Yes, sir.
Will issue notice at this stage. Heard Mr. A. Jimomi, Learned Counsel for the applicant, and Mr. P. Jimomi, Learned Counsel for the Learned Government Advocate, for the opposite party number 1, 2, 3, 4. 1, 2, 3, 4. This highway. Moazamil, can you accept NHIDC? Or we have to issue notice first? Okay, you get appointed later on. Okay, that.
It was better.
Okay. This application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 3 to 3 days, which period of delay has occurred in preferring the accompanying review petition against the judgment and order dated 25/10/2024, passed in PIL number 2/2024. Issue notice returnable 4 weeks, as Mr. P. Jimon Learned Government Advocate has appeared and accepted notice on behalf of the opposite party number 1 to 4. Our issuance of formal notice to the said opposite party is dispensed with. The opposite party, number 4, 1 to 4, shall file its objection to the application for delay, application for considering the delay, comma, if so advised, comma, on or before the returnable date. Post of the applicants shall take steps for service of notice upon the opposite party number 5 to 8 by speed post within 3 working days from today. This is the case after 4 weeks.
From the supplementary cost list for orders, item number 24 and 25.
Please, Lordships. My lord, if I may be able to take your lordships to the order passed in the IA.
There is a conviction under what?
Section 6 of the POCSO Act.
Section 6 of the POCSO Act. Have you filed objection?
This chief was informed the chief, but I need to receive that confirmation whether like the informant is being informed or not. Chief. Firstly, and secondly, on the last order, I was supposed to bring the medical report, chief, regarding the state of the mental state, health state of the accused. But chief, so accordingly, I received this information.
Apart from the conviction, there is presumption, strong presumption.
Look, here, in this case,
Let me find out. It is, this is happy.
Also, there's no one.
It is.
Infection 38 years.
Following invasion of facilities.
Okay.
This also I don't know. This one. Make it very squeeze and this.
This is 7.
You see. Giving this. Maybe the report. What is it? Maybe someone, what is it in? That one. The question is. What is this? What kind of treatment he needs?
He needs to remove his gallbladder stone. That is-
Yes, Your Lordship,
Because myself, I'm not acquainted with all these medical terms, right?
yes, Your Lordship.
I don't know what is
That's related to
cholecystectomy.
gallstone.
Hmm?
I-
And your documents are very illegible.
Yes, Your Lordship, because since the one to make up the method, that's why Your Lordship urgently. Otherwise, all the
I have
documents
the-
has to be.
I have
as
the next some of the
empty.
documents and also the next.
Mr. Takakichu,
Yes, my lord.
a suspension of sentence is ordinarily on merits.
My lord, yes.
Right. First aspect,
My lord, yes.
right? And this is an emergency situation you can call, right?
Yes, my lord.
And that may be suppose the father or the mother of the convict dies. He is allowed to go out to attend the funeral and all for a period of 1 month. Similarly, a person, the convict, is having any health issues, the treatment for which is ordinarily not available inside the jail and to the jail doctor, or by taking him to the nearest medical facility and taking him back from the hospital, jail,
Yes, my lord.
right? Then the next extraordinary situation arises where he needs
My lord, allow me.
to be, no, please, where he needs to be taken
Yes, my lord.
for medical treatment and where a surgery is a necessity, right?
Yes, my lord.
From your medical report, any objection filed already?
No, Your Lordship, I just got the received the report, that is the only thing, and so far, like, they're taking care of his health, and we are supposed to, I also sought for.
My lord.
What is the time required? Who will spend the money?
My lord, allow me to explain this facts a little bit. My lord, this is a very peculiar case. Here in this case, the accused as well as the victims all are blind.
Huh?
All are blind. Even the accused here is 100% blind. He always need the assistance of someone, even during normal days also. So even in the jail, he always needs the assistance of someone for his.
So far, report says
Okay.
he has been provided with all the assistance inside the jail. That has no merit.
He was carrying the medical.
No, other
Take from-
inmates, jail staff, there is a report. Mr. Takakichu, let us be limited to what?
Okay.
Inside the jail, he has been provided with all the support by the other inmates as well as out of sympathy or whatever, as a brotherhood. And all the jail staff are providing with all the care and right. Question is regarding surgery. His stay inside the jail is okay as per the report. So your contention against her contention will balance, ultimately will go into the merit of the judgment. So let us be practical.
Okay.
So it says, the report says about some surgery, right?
Yes.
Some surgery.
If that would be with regard to gallstone.
Huh?
Gallstone.
Gallstone.
He has been referred to a higher center.
Higher center means
CHSR.
CISR.
The center is near the hospital.
Hospital only.
It's near 5 minutes.
5 minutes.
Yes.
That is why I have asked you the question, who will bear the expenses?
of course, the family members of the accused.
Okay.
No, Your Lordship, one thing is that like.
He is a convict otherwise.
Yes, Your Lordship, so I don't have any.
Ah.
As far as the health is concerned, Your Lordship, we also have equal concern for that. Your Lordship, I was actually telling the jail also, like whether the board of doctors can be constituted so that like exact,
Right, this is the right procedure.
Yes, so when I asked him, he told me that there should be a direction from the court, that there should be a direction stating that let the board of doctors be constituted so that like to examine the case of that. So on that line.
Because this
I-
is
This is-
superintendent of jail or
Yes, yes.
somebody.
So the correct procedure will be, a direction should be there for constitution of the board and let the board of doctors examine this case, then only if they need a rise for surgery, then Your Lordship, we will see what steps we will.
Because things can be done.
Yes, Your Lordship.
Because he is lodged in which jail?
Yes, Your Lordship.
Which jail?
Central jail.
Central jail, what, where?
Dimapur.
Okay, Dimapur. Dimapur. And this CISHR is also in Dimapur.
Yes, just for
Right.
us.
So it can be done through the jail authorities also.
Yes, Your, that can also.
That is one option. The other option is by treatment by the family,
Yes.
right? And laparoscopic surgery is not a matter, not a very big thing. It can be done within 1 hour, right? People get admitted in the morning, comes out in the evening. It is such a kind of surgery. All these rays,
Condition now.
right?
Condition now.
So we'll ask the medical board
Yes, Your Lordship.
to go through the same whether after surgery, pre-surgery, post-surgery, the convict requires care which can only be provided by his family members.
Yes, Your
Because it is POXO, sir.
Lordship.
Not even 302. Not even 302.
Even on merit also, I have a case, madam.
You may have a good case, you're not into. For that, she has to file an objection. Thereafter, we can consider. We can do what we can direct to constitute a medical board.
Your Lordship, my humble request is that let the board of doctors examine him and see the nature of the like whether the surgery is required or not. If so required, as Your Lordship has suggested, like whether the care and need will be required post or pre.
Because otherwise it is a normal because he has
Not
committed.
normal, then the
Because-
jail authority can take you to the hospital.
He was.
It is not a case that he has to be taken to Kohima or to Gauhati. It is,
The civil hospital has referred the matter to the CHSM because their facilities is.
but normally after, if it is complicated operations, then it needs care after,
Yes.
after operation, post-operation care. But otherwise, it is, gallbladder stone is normal thing. And laparoscopic surgery is also normal. It is by ray, everything is done. So we'll ask.
Yes, Your Lordship, that will be.
And it is not that serious issue. Every 50% of the population has this problem, right?
I have also.
He was blind.
Huh?
He was blind, he was blind, when he committed offense, blind committed
Blind.
offense
committing
against
offense.
blind.
Blind.
Hmm.
Serious issue.
Yes, that is why, in the blind.
I, Mr. Taka Kichu, learned counsel for the applicant appellate, and Ms. Livika, learned public prosecutor for the respondent state. Post of the objection to the application seeking suspension of the execution of the sentence passed against the applicant appellant has not yet been filed by the state. Post of further sought for, further 4 weeks is granted to file the written objection on behalf of the state. Post of on the previous date, the learned counsel for the applicant appellant had submitted that the applicant appellant has been suffering from gallbladder stone and fatty liver issues, and those are required to be addressed by availing medical facility outside the hospital or jail. Post op. Ms. Lipika was directed to obtain instruction in the matter from the jail authorities and the doctor concerned. Post op. Today, Ms. Lipika has faced a letter from the senior letter dated 5th of December 2025 from the senior superintendent of jail, Central Jail, Dimapur, wherein it is mentioned that when the applicant appellant was taken for review to the district hospital, Dimapur, on 4/12/2025, it has been advised for he has been advised for medical treatment at a higher medical center, VIZ, CIHSR, a referral hospital, where facilities for cholecystectomy and laparoscopic surgery are available. On the basis of the materials placed, this court is not in a position to arrive at a view whether the applicant appellant can undergo such medical such surgeries from jail, or you need post operation, you say care. Which post-operation care outside the jail. In the above view of the matter, this court is of the view that a medical board is to be constituted to examine the applicant appellant and to suggest the measures whereby the applicant appellant suggest the measures namely more particularly whether the applicant appellant can be provided the required treatment by keeping him inside the jail, or the applicant appellant needs special care and protection after undergoing the surgeries, if required for laparoscopic surgeries. It's very difficult to predict. We have short time, 14 then.
Specific direction, like to constitute a board, to remind me. So that itself.
it is therefore directed to constitute a medical board and to submit a report on the aforesaid aspects on the next date of listing, 14/1/2025. Please the case on 14/1/2000. Because it is POXO, other cases we have. Madam, you filed the objection,
Yes, sir.
and if required, then he will be allowed interim bill for 1 month, 2 months, whatever. But not full suspension.
My lord.
Ambulan and ambulan. I don't know. I don't want.
Mau putai di itu. Itu putai di si jela tu.